You know, it's yeah.
Good to see you.
You know, okay, vendors downtown around the square.
Very proud.
Never seen more. At all.
You know, you never know. But that have a road. Okay. I don't want to go here, so just well. Yeah, exactly. Man, you never know. All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. I want to welcome everyone to the 10th Court of Appeals session being held on the campus of the MCC Community College. It's truly a privilege to get to be here today. This is partly because the legislature authorizes us to hold court in the county seat of the 18 counties that make up our Court of Appeals district. It is also because of the gracious invitation of your president, Dr. McCowan, and I'm looking for her, and here she is in the back. Dr. McCowan, I will yield, the microphone to you if you would like to say anything to those assembled. I wonder if I should start my 3-minute timer.
It will take a minute and a half at the most. I just want to thank y'all for being here today on behalf of our students and the Board of Trustees, and the Social Sciences Division, paralegal and law enforcement, and those who are here. We are honored that you've graced us with your presence today. Thank you.
Thank you. Thank you for the invitation, and I hope that we do not disappoint. We have 3 cases scheduled for today. One is scheduled at 10 o'clock, one at 11, and one at 1:30. Y'all are welcome to attend any part of or all of the 3. We do allow folks to move around during the argument if you need to. I ask for that as movement with manners. Remember, these are real cases. These are real problems that have been presented to this court for resolution on appeal, and they've been tried in the trial court. So if you're expecting to see a Perry Mason moment with a cross-examination of a witness that suddenly caves and admits to the offense, you will be disappointed when you leave, because that is not going to happen today. What will happen after today is that the judges on the panel, and I'll get to that in a moment, will retire back to the courthouse here in Waco. We're located on the 4th floor of the McLennan County Courthouse. And with the able assistance of our staff, we will, which is seated over here on you all's far right, the staff and the judges will review the case law and the briefing in these cases that are presented to us. And then we will make a decision, and we will prepare an opinion and issue that opinion for all the world to see, in effect. The way that you all can follow what happens after today is in the pamphlets that are on the back table. If you didn't get one, you need to get one of those. There is a website in there that you can log in, and you can log on to a particular case, and you can sign up for what's called case mail. And then anytime after you sign up, when something happens in that case, you will get a notice. And then you can log on to the website, go to that case, and see the document that has been filed. It may be, we may ask for supplemental briefing after today. And in that instance, the parties will file something with the court after today, and then you'll get a notice of it. If you've signed up for case mail, then you can go and see what's happening. We will do that when the case opinion is issued and the judgment, and then you can go on and read that opinion and see how the case turned out. Then if the parties disagree with our opinion, and almost assuredly one side or the other will disagree, they may choose to file a motion for rehearing with us. You'll get notice of that. And then if they file ultimately for review by one of the state's high courts, then you will also get notice of that. So that's the way to keep up with what happens in these cases today. I do ask that you turn off or silence your electronic devices. And the panel today is Steve Smith on my left, Rex Davis on my right. Now, Rex is not currently an elected justice on this court. The elected justice on this first case happened to be the trial court judge at the time that it was tried. And so he was involved in the development of the case. And so he can't sit. It's what we call a recusal. He's actually sitting in the back because, Matt, raise your hand there. Matt will sit with us on the other 2 cases that he is not recused on. And so, after this first argument, we're going to have a change out of justices here on the court. Rex used to be on the court. He is assigned by the governor, by the Supreme Court, Chief Justice of the Texas Supreme Court, to sit with us in any of the cases that we assign him to. So that's one of the differences, and kind of one of the unusual things about the cases y'all are going to see today is that we do have a recusal on a case that we're arguing on campus, and we seldom do that, very seldom. The other things that are unusual about us having argument on campus today is that we'll let you take photos if you want to. It's, we don't normally do that in the courtroom. And then the other thing that is unusual that we don't do in the courtroom, because you all are here, we ask the attorneys to turn to you for 3 minutes and explain either the facts or the case law to put in context the arguments that you're going to hear them make to the court. And we've got a little tweak on even that today that is going to be a trial basis. Counsel have agreed that the state is going to present the 3 minutes for both of them. And so it's going to be first, counsel for the state is going to talk to you all for 3 minutes, and then counsel for the appellant will come up and make her argument directly to us. Then the state will make their argument, and then the appellate's counsel will have 5 minutes for rebuttal if they choose to use that time. Also, at the end of the second case today, probably somewhere around noon, we will have a Q&A session. So anybody that has questions, I think Lindsay, where are you, Lindsay? In the back, in the pink, I think she was going to try to filter the questions, so write them up and give them to her. But at the same time, we'll probably take them on the fly as well. Obviously, we can't talk about the cases that are being submitted to us, but we can answer any of the questions that are general in nature. Today is September the 17th. It is Constitution Day. And I have asked Steve, who is pretty much directly responsible for us being here from a conversation I had with Dr. McCowan, for us being here on this particular day. And I would like for Steve to take 2 or 3 minutes to explain to those assembled what Constitution Day is and so why we're here today.
Yeah, normally we have our oral arguments on Wednesday, but today's Tuesday. And the reason we are here today is because 237 years ago, some fellows were sitting in a very hot room in Philadelphia, Pennsylvania, during the Constitutional Convention and adopted the Constitution of the United States. 2 years later, they came back and did a few amendments in 1789. The Constitution is the bedrock of our country, and we are the only country in the world today that I know of that is still operating under the oldest Constitution that we have existing at this time. We have to follow it, even though we're a state court. We are bound by the Constitution of the United States, as is every other state in the Union. It's not perfect. It's probably a little flawed because imperfect human beings were the people that created it. But because of the fact that we have the Constitution, in my opinion, we have the finest type of government that we could ever have, a representative democracy and a representative republic. And think about that. Think about those. And at the time, it was all men. Ladies, no offense, but this is 1787, okay? It was a different time and place. But I think we're extremely lucky to have the Constitution that we have. And I hope you will join us in celebrating it each and every day.
Thank you, Steve. At this time, I call, and I will undoubtedly mispronounce this man's name. Latashka versus state. And I would like announcements from council. Are y'all ready?
State's ready. Appellant's ready.
You may, let's see, you're going to present the 3 minutes, so
Justice Gray, we did agree to kind of riff together and maybe do
Oh,
a little
okay.
bit of 90-second share.
y'all approach and talk to the students as you think appropriate. Since y'all are combining your time, if it runs a little over 3 minutes, I will not stop y'all. So.
All right, good morning. What we have today is a case about a 4-year-old named KK. KK, is the nephew of the appellant, Mr. Latoshka. KK's mother, Ashley Farley, got a phone call from Crystal McCartney, who is the appellant's girlfriend at the time that this offense came about. Ms. McCartney told Ashley that she believed that the appellant had been inappropriate with Ashley's child, KK. What Ashley found out was that the appellant had been forcing KK to watch Crystal McCartney shower naked, that he forced him to watch pornography, and even taught him how to engage in sexual acts with women. Ashley Farley naturally asked her son KK about this, and KK confirmed that the appellant had been doing those things. As a mother would, Ashley Farley asked KK, has anybody been touching you in places where people shouldn't be? And KK confirmed, yes. My uncle, Colin, who he also called Wawa. With this information, Ashley Farley reported this to the Robinson Police Department. And from there, a CPS investigation started, a criminal investigation started. And KK was ultimately interviewed by not only a forensic examiner, but also a forensic medical examiner. It is at this time that KK reemphasizes that he had been touched inappropriately by his uncle, and very specifically admits that his uncle had penetrated him anally with his finger. This case is ultimately tried in the 54th District Court in McLean County. And after hearing all of the evidence, the jury decided that the appellant was guilty of the offense of aggravated sexual assault of a child. The appellant received 30 years prison from the jury and a $3,000 fine. And so the issue presented on appeal is whether or not, if KK had testified differently at trial from the statements that he made to his mother, is the evidence sufficient to support his conviction for aggravated sexual assault of a child? Additionally, during the trial, KK had been unable or at least failed to identify the appellant as the person who committed this offense against him. So that is another issue that will be addressed, whether or not the conviction is supported by the evidence if the child failed to identify him in the courtroom.
I'll jump in here, so in the spirit of just ripping off of that, ultimately what happens is KK shows up at trial to testify, and he says what the medical examiner, forensic interviewer, CPS worker, and mom say I said. He gives a different account. He doesn't deny that he told those statements. He isn't even asked about them. But what he says is something else happened. And what he says happened is that he was touched on the front part of his body, penis, with a hand, not on the back, anal digital penetration, which he had said, according to the witnesses that testified, is what happened. So the question before the court is this a different and materially different scenario than other Texas cases that say a contradiction is typically going to be something a jury can resolve? I'm going to be arguing today that this is a materially different circumstance, and that for the jury to have convicted my client based on the indicted conduct, which again, with anal digital penetration, when he comes into court and says something different, that was not a rational decision for the jury to make.
Thank you, counsel. And counsel, you may proceed with your argument from ready.
Thank you, Justice Gray. Good morning. May it please the court, Jesse Freud for Mr. Latoshka. So like I was just telling the students, Texas courts have said that outcry testimony is evidence of guilt that by itself can be sufficient to support a conviction beyond a reasonable doubt. A question this case presents is, but is it always? The answer should be no. As in this case, when a child witness testifies about an allegation of abuse and says, this is what happened to me, and that alleges an offense, which is going to be different than the cases we talk about, and says the indicted conduct did not happen, the hearsay or outcry testimony, even though it still has probative value, should be insufficient on its own to sustain the conviction. the relevant cases of Chambers, Rodriguez, Villalon, and some others that the state cited in their briefing, Saldana, and Justice Gray, I found Martinez, an unpublished case from 2005, where you dissented, and I hope we can talk about that, because I have a feeling some of the concerns you had in that case you may have here. But ultimately, all of these cases, I think, support what I'm asking the court today. But before we start talking about the cases, I'd like to give a brief factual overview, a little bit more tailored than what Ms. Fuentes gave to the students, if I may. So we have 7 witnesses at guilt innocence that the state presented. We've got the 4 hearsay or outcry witnesses: mom, the CPS worker Avery Wiley, medical examiner Dr. Sue Battle, and forensic interviewer Carrie Berkeley. Between August 10th and August 18th, all 4 witnesses testified that KK ultimately said, "I was anally, digitally penetrated by my uncle."
And for clarification, that is the offense for which he was indicted.
Correct. Yes, sir. And so we have State's Exhibit 2, which is Dr. Battle's medical exam, where she memorialized his statement. We have mom's testimony in court, where she says, "That is what KK told me on the 10th. We have the CPS worker who did not testify to an exact statement, but what she said is that the statement he made to her was consistent with the forensic interviewer's statement. And ultimately what Carrie Berkeley, the forensic interviewer, testifies to over defense objection is anal digital penetration as well. So we have those 4 statements. Even though the CPS worker doesn't repeat that, it is essentially an inference based on the record. So getting to KK's testimony. KK testifies over 11 pages from 247 to 258. His substantive testimony about the event starts at 250, so it's about 8 pages of testimony. And he was cooperative, articulate, responsive, and he testified consistently with the surrounding circumstances of the event that the outcry witnesses testify about. That he was 4, he was at grandma's, he was going to the bathroom, and he talks about same thing, what happens after, how he reacts after, what he does after the event. But where the testimony diverges is the conduct that he said occurred. He says in a free-flowing narrative, similar to what Carrie Berkeley says he did in the forensic interview, he says, "My front spot was touched, not my back spot." And I want to take a minute here to look closely at page 251 of his testimony, because the state's brief on 2 pages, I think, makes a material misstatement of that, I'm sure, accidentally, but I can see how down the line it could get repeated. So I'd like to look at it. On page 6, the state's brief says, KK indicated that someone touched his front and back spot. And then on page 12 of their brief, they say, when KK testified in court 3 years after the offense, he stated that someone touched his bad spot, specifically his front and back spot. But when we look at page 251, what that testimony really is him just identifying and defining what bad spot means. And that's consistent with what mom testifies when she says, here's how I've taught him to talk about his body. Bad spot, or a no-no area is what she calls it, is his front and his back spot. So on 251, you're starting at line 16, and he is asked, after first, when he answers the question, what happened? He responds, someone touched my bad spot. The question to him then is, can you help me understand where on your body is your bad spot? And he defines it. My bad spot is my front spot and my back spot. And then he's asked specifically about the touching. So where of those 2 locations were touched? And he is very clear, it is my front spot. So in the state's brief, I just want to make sure that we don't have a misstatement of that testimony. That is him defining the areas, that is not him saying both locations were touched. And so moving on to a characterization of his testimony. You may tell from the briefing that I was pretty intentional with calling it a denial and not a recantation. And the reason I was intentional about that is because recantation, I pulled the Black's Law Dictionary definition. says to take back or to withdraw a statement that has been made to repudiate. And the way the testimony reads to me is not that he is confronted with or has an awareness about, I said that, so now I'm saying this. So I don't read the testimony as him making a knowing withdrawal or repudiation of the prior statements that have been attributed to him. But what he does do very clearly at multiple parts, the 3 denials, he is asked, has your back spot been touched? No. And he says that over and over and over again. And so looking at the characterizations on some of the cases that we're going to talk about, when we talk about Rodriguez is a case where the complainant essentially clammed up in court, couldn't give enough of a testimony to give a complete overview of the event. But ultimately, what the CCA said in Rodriguez, which was actually a 5-4 decision. So it was really close. Clinton, Maloney, Benavides, and Overstreet dissented. And ultimately, they said, looking at the complainant's testimony, she did not testify inconsistently with what the outcry witnesses said. So even though Rodriguez does have the statement that I think is repeated in many cases, which is that the outcry testimony is sufficient to support a conviction beyond a reasonable doubt. Ultimately, what Rodriguez says is the outcry testimony plus the complainant testimony was sufficient. So it's a statement, but the holding does not just rely on the outcry testimony alone. And I think that's important. And then the other cases follow that, which is trying to decide if there is a contradiction in the testimony, if there is a recantation. Looking at Chambers, we went from crime to no crime. But importantly, and something I think is absent here, is that in that case, there were other surrounding facts and circumstances that the jury was free to evaluate about why we would be going from a statement of crime to no crime. And ultimately, there were facts in the record that supported that the change in position was motivated by a desire to protect and love the defendant and not want him to get in trouble, which again is very different from the circumstances that we have here. We have no similar facts like that here. What we have here.
2 quick questions. First of all, do we evaluate the fact that he was 4 at the time of the event, 7 at the time of testimony? Does his ability to articulate the offense, differentiate the offense, how are we to weigh that? And then in the context of what we are trying to decide, does it matter that none of the outcry witness testimony was objected to at the time that it was admitted?
I'll take the easier one first. The latter question is no, it doesn't matter. For sufficiency review purposes, we got to consider it all. So it has to be included in the analysis. So the answer to that is no. How do we weigh it? I think there could have been an opportunity for that point to be flushed out in the testimony, but I think the only thing the record reflects is that Dr. Carter proposed some suggestions as to why we could be getting a different story in the courtroom. One explanation he gave is memory lapse. I think the record does not support memory lapse at all. He is, again, KK's testimony is very clear. He remembers everything, again, that is otherwise consistent with the event. So we know he's talking about the same thing. He doesn't say, when it gets to the question about how he was touched, he doesn't have a memory lapse there. So while I think Dr. Carter gave that as one explanation, I think it is something that is proposed, but that to apply it to this case would be inappropriate, and I don't think he did that. And then another reason he gave would be fear of the defendant. I think the record contradicts that. Mom's testimony was that he was never afraid of my client and that he loved his uncle. And the only other point in the record where I found that fear is asked of him was in Dr. Battle's testimony. She says that sometimes she will ask the child, about any fear of the person the child is accusing, and that she did not ask that in this case, so we don't know what he may have said to her. And then he gives, fear of public speaking as a third reason that maybe we're getting a different account. And I also think that that is unsubstantiated by the record. Different than the complainant in Rodriguez that clearly, right, asking for her coloring book, doesn't want to be there, not participating, not cooperating. We don't have that from KK. He is direct, he is articulate, he is clear. Mom is asked at some point, how is his memory? She says he has a great memory. One thing I think that Dr. Carter does ask, or does talk about or opine on, that I think actually weighs in favor of the in-court statement versus the out-of-court statement, is that now that he's older, he has better language. And so we could be seeing a change in account now that he has more sophisticated language to explain what he says happened. Which,
I was just about to ask a related question, and I have noticed as we move forward in the argument that I have trouble distinguishing back from bad. Bad has two body parts, back is one. Is there anything in the record that suggests that at 4 years old, there was an inability to clearly articulate, not differentiate, but articulate the verbal word back instead of bad? In other words, at 4, he says he touched me in a bad spot. And it gets written down as back spot instead of bad spot. Is there anything in the record that would support that type of differentiation?
I think there is. I was thinking about that as well, thinking about how, right, because we have a trickle down of the statements, right? Starts with mom, then it goes to CPS, then it goes to the interviewer, and then it goes to Dr. Battle. So trying to understand about how that could happen. One point that may answer your question, Justice Gray, is when mom says that he didn't say what exactly happened, that he demonstrated. And so her understanding of the initial statement that he made when he answered affirmatively to, were you touched, that he demonstrated the answer. And then ultimately, shortly after, I believe this is when she talks about the event after he's going to the bathroom at the radio installer shop, and says after that day, he comes into her room and then uses words. So I think that's the best answer I can give, which is initially it is by demonstration and not by articulation. But going back just to the spectrum of complainant behavior and trying to decide, does this fit in a existing bucket of complainant in court behavior, or is this something different? In Bradshaw, which is one of my cases from last year, where I raised a similar argument, and ultimately the court said that in that case couldn't. So again, complainant behavior, I think, was an example. The court said that that complainant just didn't remember, and ultimately her testimony was not inconsistent with the outcry. Again, Rodriguez is clamming up. Chambers is crime to no crime. Villalon and Saldana, which Saldana was cited by the state, those are ultimately, I think, just imprecise language cases. Those complainants in both cases ultimately give testimony that could reasonably infer the indicted conduct. I don't think it's a close call, so that is not the same here. And then I know Fernandez was cited too. Fernandez is a car theft case where the girlfriend recants. And ultimately, I think it's the same analysis ultimately with Rodriguez and Chambers, which is, although the court says that outcry testimony can be sufficient by itself, it ultimately does not hold that. And Chambers, I'm pretty sure too, was a 4-4 plurality opinion. So these were close calls on close cases. And it looks like the Court of Criminal Appeals, ultimately, there was significant disagreement about when a child complainant comes into court and materially contradicts their out-of-court statements. What do we do with that? And it looks like what we do with that is look at the surrounding circumstances and what else is there. And Dr. Carter's testimony ultimately, I think, encouraged that too. I've got that here. Dr. Carter says on 3RR 271, he doesn't tell the whole story as has been related before, you have to determine, well, do we solely rely on his statement? He has more language now, he has more understanding now, but do we solely rely on that? Earlier, he says you always look for corroboration. And I think, again, even though we have this recitation of a statement that the outcry testimony can be sufficient by itself, what ultimately the analyses look at are the corroboration. And I think the testimony at trial encouraged that interpretation. Justice Gray, I want to get to the dissent of Martinez because I see how I lose, and I think it's through that dissent. And so I agree that the concern that it looks like you had in that was with how the majority phrased their discussion about the outcry testimony. But I think what Martinez correctly does not do is it does not exclude the other evidence, the outcry testimony. And Villalon, Chambers, and Rodriguez, that's what the Court of Criminal Appeals is ultimately hollering at the courts of appeals for doing, saying you were essentially making an admissibility determination and then applying that to the sufficiency analysis, and you can't do that. And I'm not asking you to do that. Do not do that. But the majority specifically does say they are giving probative value to the outcry statements. I think what the implied holding is, though, is that those outcry statements cannot be sufficient to sustain a conviction beyond a reasonable doubt when a complainant credibly denies the indicted conduct. And I think that's what we have here. I think we have a credible denial and an unchallenged and unimpeached denial of the indicted conduct, which otherwise should be insufficient to support the conviction because he didn't come into court and talk about that. He credibly said, this is what happened to me, and it wasn't the indicted conduct. So for those reasons, I'd ask that you find the evidence is legally insufficient. I'll talk to you again in rebuttal.
Yeah.
Thank you.
May it please the court, counsel. I want to start with going over a little bit of the finer details of the testimony that came out in trial, because I think Chief Justice Gray brought up a good point about what exactly this child was able to say with his words around the time of the offense. The first person to testify in the state's case was Dr. Battle, who conducted the medical examination of KK. She indicated that when she talked to KK, not only did he identify Colin Latoshka, or who he referred to as Wawa, as the person who had touched him, but he specifically stated that Wawa touched his butt in the middle, in the hole with his finger, and that it hurt a little. Dr. Battle also talked about some of the behaviors that Ms. Farley had brought up during the investigation, which was that KK was engaging in behaviors that were odd to Ms. Farley, but suddenly made sense whenever the outcry of sexual abuse came about. Specifically, KK had been humping stuffed animals. He had been getting erections whenever being held by his mother. And he was wanting to see her frequently naked. And whenever Ashley Farley did not allow her son to do this, he would become upset. And the next person to testify is Ashley Farley. What she says is that initially when she asked KK if anyone had touched him before, he says, yes, Wawa. And he, as appellate counsel just mentioned, kind of demonstrates with his hand. And Ashley Farley describes this as his hand going into the crack of his butt. And so later on, KK goes further with that description and says that Wawa stuck his fingers in my butt and it hurt. The next person to testify was the CPS investigator, Avery Wiley, who indicated that during her interview with KK, he had made an outcry of sexual abuse, and just like counsel stated, it was consistent with the outcries that had been made previously. The next person was Detective Mathis, who was the person who really set up the forensic interview. He did not speak, or she did not speak to the child herself. However, the next person, Dr. Berkeley, who is with the Child Advocacy Center, who did have an opportunity to interview the child, does get a statement from the child, which is admitted into evidence during the course of trial, that KK stated, his butthole was almost biting my finger. And then, of course, KK testifies himself during the course of trial.
Counsel, before you get to that, the trial testimony, were all of the outcry witnesses based upon statements that the complainant made in the days immediately after the events, the discovery of the events? Or were there other evaluations by these people closer in time to the trial?
So these statements made by KK were close to the time of when the initial outcry came about. So when Ashley Farley asked her son if anyone had touched him in his known areas, the moment that she realized that the appellant's hands had gone into a place of the child's body where it was not supposed to go, she immediately went to Robinson PD. And from there, a forensic interview was set up. It was actually set up for less than a month later, but because there was a concern about the appellant fleeing the country based on a statement by his girlfriend at the time, they moved that forensic interview up to where it was just a matter of, I believe, just days later. And
So it wasn't like, psychological testimony or testimony from a psychiatrist that may have covered several years of discussions with the child. All of these were around the time he was 4 years old or so.
You are correct. This was all in a very short amount of time. Robinson PD Detective Mathis testified that she put a rush on getting the warrant because of the concerns about the flight risk. And so they used the information that they had at the time, what stemmed from the forensic interview and the statements that Ashley Farley had given to the police department, and immediately got a warrant. And so, yes, these statements were all very close in time. And so the only testimony that was so far spread out would have been his testimony at trial, which was 3 years later when he was 7 years old.
Okay, and you were about to go there, so please proceed.
Thank you. So KK does testify at trial, and I agree with appellate counsel that there is certainly a discrepancy between the state's brief and appellate's brief, but I do think that there is room for interpretation when it comes to what exactly KK was saying at trial. Of course, we were looking at it in black and white as opposed to being there and understanding what exactly was meant. But I will say that even if KK had only stated that his front spot was touched, the fact is that he did not admit to penetration of the anus at trial. That is a fact. And so the last person.
You're saying he did not state that affirmatively that there was conduct that would have, in effect, proven the allegations in the indictment.
By itself, correct.
Okay.
He's not.
He didn't say no, but he didn't say yes.
I think the question posed at trial was whether or not anybody had touched his back spot. It wasn't so specific to completely close out the idea that he was not penetrated anally. At the time, the jury's free to believe that maybe at the time of trial, KK is confused or he's having, a failure of memory because so many years have passed. And that's exactly what I'm getting to next, is that Dr. Carter is the last person to testify to kind of explain why KK might have said his front spot was only touched by the appellant as opposed to the back spot. And so Dr. Carter goes over the various reasons for child testimony becoming inconsistent when it comes to trial. Dr. Carter talks about how a child between the ages of 4 and 7 go through a lot developmentally. And so because of that, there might be a failure in memory. He also discusses that trauma might affect memory in a way that a child purposely closes out things so they don't have to remember them because they are so traumatic. And when the jury's hearing KK's statements in trial, they could have certainly believed that KK was nervous. Of course, like I said, we're reading something that's in black and white now, but we don't know what KK looked like or what he sounded like by just merely reading the record. And so the jury could have certainly, ultimately, because what they do decide is that the outcry statement has weight and that it is probative in establishing the defendant's guilt, because they do find that he's guilty of aggravated sexual assault of a child.
Is there any, significance in the fact he kept saying no to every question? And I understand your theories about how things have changed, but is there any significance in the fact that he was not even able to identify the person who is his uncle sitting at the counsel table?
Right, so to answer the first question about how many times he said no, the child could have said no once, or he could have said no 50 times. I think that the state's position that memory could have certainly failed him is reasonable to believe, and that's something that the jury could have believed at the time. As you know, they're in the best position to look at this child and determine, are they being affected in a way that they either can't remember or refuse to remember what has actually happened to them, what they have previously stated to other people. And so I missed the last part of your question. Do you mind repeating that part?
Well, is there any significance in his testimony when he is asked, do you see anybody at the counsel table? You know, he can't even recognize his uncle.
Right, and I believe the record goes into this situation where Ashley Farley CPS got involved, and the reason why CPS ended up closing their investigation is because Ashley Farley had agreed to keep her son away from appellant. And so from my reading of the record, it doesn't appear that the child, who was 4 years old when this happened, had been around his uncle from that point forward. From the time that this offense was reported to Robinson PD, I don't think KK was around his uncle after that anymore. And so what the jury could certainly have believed at that time was so much time has passed that he possibly just doesn't recognize this man in the courtroom. But what the child does do is identify the appellant by name. He says, when asked who touched him, he specifically says, Colin. And he also identifies him by the nickname that he had always known him by, which is Wawa.
Question,
Yes, sir.
a little bit more about Dr. Carter's involvement. Dr. Carter was obviously a live witness at the trial. He's an expert, longtime expert, very, very fine psychologist. Did the process, first of all, did you try this case?
I did not.
Okay. Did Dr. Carter have any opportunity to interview full or mini psych valve of any kind of the victim, alleged victim, before trial?
I do not believe that a psychological evaluation was done on KK for Dr. Carter to review. I also don't think that Dr. Carter had an individual conversation with the child. Rather, Dr. Carter just testified to things that are common in the field, that are well understood within the field of psychology and specific to child witness testimony.
Okay, and that said, do we draw from that Dr. Carter was not provided other materials that y'all have described were created by the other experts over the long haul from age 4 forward? Do we know whether he had the benefit of those materials ahead of time, or was his testimony essentially hypothetical?
I do know that normally Dr. Carter will review what's available,
Right.
and part of his opinion or his, you know, the testimony that he might offer during trial to assist the trier of fact will be based off not only psychological evaluations, if he's conducted them, but also a review of the offense report. I'm not sure if that was done in this specific case, but I will say that there is a multidisciplinary team when it comes to crimes against children cases where multiple entities are involved. So we're talking Robinson PD, the Child Advocacy Center, CPS. And so Dr. Carter might certainly be involved with just helping you know, everyone to understand what might be going on with this child, but I'm not certain if he was really involved with this agency's investigation. Rather, I think he was used during this trial to just explain child behavior when it comes to sexual assault.
All right. Thank you for that explanation. Appreciate it.
So, as I stated during our brief recitation of the facts to the students and the rest of the room, the jury ultimately decided that though it was posed with what appellant counsel might describe as an inconsistent statement, the jury decided to believe and put weight on the outcry statement that was given to Ashley Farley, and possibly also the outcry statement that was given to CPS, the forensic interviewer, and Dr. Battle, who conducted the medical examination. As counsel stated, the outcry statement alone is absolutely sufficient to uphold a conviction for aggravated sexual assault of a child. There is no requirement that that statement be corroborated by the victim's testimony or any other independent evidence. And the reason I provided two cases, something that appellate counsel mentions is that this is a denial of the charged conduct rather than a recantation. And I think it's just a play on words, because the reality is that the child, for sufficiency purposes, the child does not admit to the charged conduct that is true. Instead, he admits to what could qualify as a different offense. But in cases like this, which have been dealt with before, I'll talk about Saldana first. In that case, the child very specifically denied penetration of her vagina at trial. And this was something that had come out in an outcry statement as completely opposite. She initially had told her mother that the appellant in that case had penetrated her vagina. So when we get to trial, she says it didn't happen. And the court in that case says that even if testimony contradicts the outcry, that testimony or that outcry statement still has probative value, and it can be used to establish the defendant's guilt in a criminal case. If that goes to court and makes a different statement, something that's inconsistent with the outcry, it does not strip that outcry statement of its probative value. And this goes back to, you know, why outcry statements are even admissible in criminal cases. 38072 says outcry statements made by child witnesses are admissible. They're substantive evidence that can be offered to establish the defendant's guilt. And there's a reason why this is the case. This exception to the rule against hearsay is not just in the rules of evidence where the rest of the exceptions against the rule of hearsay are. This has its own special place in the Articles of the Code of Criminal Procedure. And that is because this is not just any ordinary exception to the rule against hearsay. This is a strong exception, and there's a reason why it has been separated from the rest of the exceptions. There's a degree of reliability with child outcry statements that may not always exist with other types of statements. And so when without alone, that is all that the jury needed in order to arrive at its determination that the appellant was guilty of this offense. It does not matter that the child ended up testifying differently or inconsistently or completely recanting the statement that he made previously to his mother.
So your case authority concerning outcry sounds almost like you're saying that outcry alone has kind of, if you will, a super sufficiency or a super weight. And I understand, I'm old enough to know when the legislature wrestled about creating a special place for outcry. I get that. But is that what you're telling us, that if this case had that alone, an outcry statement, we should believe that it's legally sufficient for the conviction?
Well, I wouldn't go as far as saying it has it has superpowers of its own, but the law is abundantly clear that there is nothing in addition to an outcry statement in order for it to have its probative value, or in order for it to alone be sufficient to support the conviction for a aggravated sexual assault of a child conviction. So it's just to say that there is no extra requirement. However, in this case, there is additional evidence other than the outcry alone. The outcry alone is sufficient. KK's outcry to his mother is sufficient. And if the jury decided when it was resolving the conflict in his testimony that his outcry statement should have been given more weight as opposed to the testimony, then they were free to do so. And that's exactly what they did. You know, they're tasked with looking at everything, looking at all the evidence. And when they decided that his outcry statement was the more believable, that was reflected in their ultimate decision that he was guilty of the offense.
Counsel, I see your time has expired. If you've got something to wrap up, please do, and otherwise we'll go to rebuttal.
Yes, Your Honor, I would just add that in this review of the evidence, it is well established that when looking at all of the evidence, it must be looked at in light most favorable to the verdict. And if the court was not to do that, it would not be deferring to the trial court as the sole judges of the credibility of the witnesses and the weight that their testimony is to be afforded. And so we would ask that the court uphold the conviction against Colin Latoshka.
Thank you, counsel. Counsel, you may proceed when ready. You got 5 minutes for rebuttal.
Thank you, Judge. Justice Craig, I want to start that the statement that it is unclear what KK meant. He demonstrates on a anatomically correct child in court and says, that's where I was touched. And then proceeds to say 3 to 4 other times, not the other location. So his 8 pages of testimony about the event is not unclear. It is crystal clear, front, not back, and he's asked every which way and doesn't sway.
Now, on that demonstration, that was in trial, but as I understood the arguments of opposing counsel, at the time of the event, when he was 4, he demonstrated for his mother or another, one of the experts, that it was the back. And do you agree with that characterization of the testimony of what happened at the time?
At the time I do.
Okay.
Yes, at the time I do. But I think at trial, there's no question that he is clear about what location he's talking about. And this idea that he refused to remember, he's actually asked that. It's one of the last questions that he's asked on 258, lines 8 and 9. Do you think maybe someone did and maybe it's hard to remember? Nobody never. So I think he's also very clear that he is not having a failure in memory, that he knows what happened. He's telling everybody what happened. And this is not I don't want to talk about it. I don't want to remember. So I think the record does not support that conclusion. As to Saldana, the trial testimony, and this is on page 48. The complainant, so it's BB, says, she said Saldana pulled down her panties and touched her from top to bottom of her middle part, where she goes to the bathroom with his finger and then does something after. Footnote 6 of Saldana is where it says that there is a denial about inside versus outside. I would characterize that as just imprecise language, but that ultimately her testimony still provided a reasonable inference that it was penetrative, and she may have not given the same answer when she's asked a magic word, but that ultimately she still does give testimony that supports penetration, which again is not the situation here. So Saldana is distinguishable. And the last point on outcry statements and the superpower of outcry statements. I think we all know that there's not such a thing. And that also, in order for outcry testimony to be admissible, a complainant has to be available to testify or going to testify. So that is also a requirement. And I think that is the statute saying, besides confrontation purposes, obviously satisfy confrontation, I think that's also saying, we're going to tell you how this all got started. And what the child's earliest statement is
but you still need to hear what the child says in court. And so I think there is an implied acknowledgement in the statute that the in-court testimony still matters.
Would you, spend just a little bit of your last time about where does Dr. Carter fit in this case, as you see it?
I think he gave some possibilities to explain why this could be happening. None, I don't think were sufficiently applied, first of all, and even if they were applied, I don't think that the record supports that. And so I think he gave possibilities to consider, which is his job as an educational expert, but I don't think that those are applied here, or at least were not properly applied and are not supported by the record.
Thank you.
Yes, sir. And so I'll end with my last 55 seconds. This court is in the position of a final due process safeguard, ensuring only the rationality of the fact finder. KK got up and he told the jury what he said happened and what happened to him, and it was not what Mr. Lutoshka was indicted for doing. The jury acted irrationally without any other reason to believe that KK was making a different statement and giving a different account. And for that reason, I think due process requires that this court render a judgment of acquittal.
I would miss, and Mr. Rooney, didn't mind you all that I think brought up some cases that, you did not cite in the brief. We will need supplemental, by Friday. We'll probably give you a couple of days till Wednesday of next week, to respond to that if there's any additional argument. But if it's just citations, then, I just need citations to any authorities that you did. It wouldn't hurt. And I would actually ask you to sort of explain your argument about the dissent and how that might fit, since you apparently found that after the briefing.
Yes,
So,
sir. And may I do it in a letter brief format?
yes, informal format of letter briefings. Fine. Anything else? Dylan?
Got it, sir. Thank you. Thanks for the opportunity.
All right, we're gonna take about a 5-minute break, allow the change of judges, and, y'all come back and see us.
Hi, guys. How are you? Well, how are you doing? Good to see you. I'm on your stage. Oh, yeah. They let me sit so yesterday and everybody was kind
Well, oh, no, he has no number.
Yeah.
Okay, Judge Davis took it. Okay, all right. Yes. No, there's one for him, yeah.
Okay. Okay.
Yeah, I don't think that's changed anything. We're call Casey.
That's it.
been doing an abbreviated announcement for the second case. If you need to sort of get the background while we're here, that kind of thing, you can go on YouTube, see the first section, and kind of the explanation of what all is going on. The one thing I would, repeat is be sure you turn your electronics to off or silent. And, anything else, gentlemen, before we begin? Okay, at this time, you'll hear 3 minutes from council for to sort of put the case in context. Council, you may proceed when ready.
Thank you, Your Honor. Is this on? Okay, great. Good morning, everybody. My name is Rick Bradley. My co-counsel Brandon Oates, we're from the firm of Haley and Olson, and we represent the city of Waco in this case. As you likely read from the pamphlet, this is a lawsuit against the city for property damage allegedly related to the death of a Labrador retriever named Finn. The basic facts are that Waco Police Department received a frantic 911 call one afternoon about a burglary in progress that involved a violent entry. The dispatcher entered the address into the city's CAD system, but the city's CAD system autocorrected, much like our cell phones do when we try to text, and it autocorrected to the wrong address, to an address that was one street over. When Officer Javon Moon and Officer Justin Day arrived at the address, they observed the back door partially open, which was consistent with the burglar call. Officer Moon approached the door with a service weapon drawn because he did not know if this was the suspect was armed and dangerous. He announced Waco Police Department. At this point in time, 5 or 6 dogs charged out the door towards Officer Moon. One in particular, large dog, Finn, charged towards Officer Moon, lunging and barking viciously. Officer Moon continually retreated to the back of the backyard until he was hemmed in by the fence. Finn kept lunging and barking at him viciously. At this point in time, Officer Moon, in fear for his life, discharged his service weapon, one shot. It struck Finn, and after he received medical treatment, Finn eventually passed away. Finn's owners have filed suit against the city alleging a number of common law and constitutional claims. Under the law, a city is immune from suit and liability unless the legislature has granted a waiver of such immunity. As we've argued today, Finn's owners, also known as appellees, have failed to establish a waiver of the city's immunity for all of their claims against the city. As a result, the trial court erred in denying the city's plea of the jurisdiction because they lack subject matter jurisdiction. That is going to be the basis of our argument today. And with that, I'll turn to the court.
Council, you'll have 17 minutes. You may proceed when ready.
May it please the court?
Hang on a second.
Oh, sorry.
Right.
May it please the court, counsel? This is a case that should be dismissed for want of jurisdiction because appellees have not and cannot plead facts demonstrating a waiver of the city's governmental immunity. As I stated in the opening, appellees have alleged a number of claims, and in this argument, I'm going to address each claim in turn and demonstrate how subject matter jurisdiction is lacking as to each claim. But before I begin with addressing the claims, we need to begin with the premise that governmental immunity protects political subdivisions, such as cities, from being sued unless the plaintiff alleges a valid waiver of immunity or some exception. This is the default rule that was promulgated by the Texas legislature. And if a plaintiff fails to allege a valid waiver of immunity or some exception, the trial court cannot exercise jurisdiction over the claims. Now, the Texas legislature has provided a few exceptions to this, and they are outlined in the Texas Tort Claims Act. This is a Texas Tort Claims Act case. The first claims I'm going to start with are the negligent appellee's argument that the city was negligent in causing Finn's death and their use of the dispatch system. In making these arguments, they've alleged that the city's immunity is waived under sections 101.021 and 101.0215 of the Texas Tort Claims Act. Now, taking one step back before we get into these statutes, the Texas Supreme Court has recognized pets as property, and that is the law of this state. So what appellees have alleged here are property damage claims under the Texas Tort Claims Act. And for property damage claims such as this, section 101.021 subsection 1 provides a waiver of immunity for negligent conduct of the city's employees if such damage arises from the operation or use of a motor-driven vehicle or motor-driven equipment. Here, there is no evidence, and there can be no evidence, that the operation or use of a motor-driven vehicle or motor-driven equipment by a city employee directly caused the property damage alleged by appellees. So therefore, they have not pled a valid waiver of the city's immunity in this case. Now, they've tried to allege a waiver of the immunity under 101.0215. It's the Corpus Christi Court of Appeals in City of Mission v. Cantu has stated that 101.0215, the TTCA, is not an independent waiver of immunity. Rather, it just brings certain municipal functions within the purview of the TTCA. To put it in layman's terms, it basically creates a distinction between governmental functions and proprietary functions. Governmental functions, immunity applies, proprietary, it does not. Appellees have acknowledged that Officer Moon's actions in the city's use of its dispatch system are governmental functions. We agree. And if that's the case, then immunity remains intact, and under the Wasson and Tukey line of cases, the city is immune. The city also asserts that both the complaint of actions alleged by the appellees constitute police protection and control, which are also governmental functions listed under 101.0215 subsection A1, and immunity applies there as well. But if that's not all, we also argue that the city's use of its dispatch system, as well as Officer Moon's actions, are accepted from the TTCA under 101.055. And what that means is that the TTCA doesn't even apply at all. Therefore, immunity remains intact. There is no waiver. We have cited to several opinions in our brief, namely the Hargrove and Vasquez cases, which both provide that the city's governmental immunity was not
Counsel,
waived.
Did you argue at trial that the emergency exclusion of 101.055 was an exclusion to potential liability? And if you did not at trial, does it matter?
It was not argued at trial, but it does not matter because we did plead that the city lacked immunity. That the city was immune from these claims. And this is subsumed within that immunity argument as well. This implicates subject matter jurisdiction for which it can be brought for the first time on appeal. So we believe that this argument can be addressed by the court in its opinion.
So you think that even though immunity as a defense can be raised on appeal, that you're not limited even to the arguments that you made at the trial in narrowing that defense?
Well, first of all, no special exceptions or anything of that nature was filed. But second of all, it implicates subject matter jurisdiction, and therefore immunity is subsumed within that. It's within the immunity, the context. I think it can be raised for the first time on appeal, Your Honor. As I stated before, we've cited the Hargrove and Vasquez cases where governmental immunity was not waived when officers shot a dog in the course of their duty to provide police protection. So there's case law to support this immunity argument. In addition, we've cited the Sawyer case, which also provided that the use or misuse of information by a governmental unit does not waive the city's immunity. And so that would apply to the use of the dispatch system that appellees seem to complain about. What we come to is there's any number of approaches that would yield the same result. The city is immune from these claims and the trial court lacked jurisdiction. Now, to move on to the next claims, they've also raised negligent training, negligent supervision, intentional infliction of emotional distress. Case law is clear on that. We cited in our briefs. The TTCA does not waive immunity for any of those claims. So those are tossed out as well. Now, the more interesting claims are appellees' constitutional claims. Appellees have failed to establish a waiver of the city's immunity for the constitutional claims is the city's position. What they've alleged is unlawful seizure under Article 1, Section 19 of the Texas Constitution, as well as the Fourth Amendment of the United States Constitution. Both of these claims will fail because, first of all, there is no private cause of action against a governmental entity or its officials for money damages related to an alleged violation of the Texas Constitution. That is the Donahue v. Dominguez case from the San Antonio Court of Appeals. Second, the United States Supreme Court in Daniels v. Williams has held that there's no private cause of action under the Fourth Amendment of the United States Constitution for negligent property damage caused by the city. And that is precisely what has been alleged here by appellees, negligent property damage. So both of these necessarily fail. Now, in their brief, appellees have requested an opportunity to amend their petition. And they want to add claims under Monell. They also want to add a substantive due process claim under the 14th Amendment, a claim under 42 USC section 1988B, as well as a Fifth Amendment due process claim. And the city once again says none of these claims will waive their immunity. And therefore, an opportunity to amend, would not be fruitful.
Why is it that if they can make out a claim under 1983 that that would not?
I would respond, Your Honor, that they can't make a claim under 1983 because it doesn't, the United States Supreme Court has held that a 1983 claim based on a negligent act of an official does not waive immunity. Whether it was intentional or negligent, that is the difference. That is the distinction.
I know it's your position that they shouldn't be given the chance to replead, but, and because you think they can't.
That's right.
But that's your belief. And so my question is not really whether you think they can make a claim, whether they should be given the opportunity to attempt to make a claim.
Given the opportunity to make a claim would be a waste of judicial economy and judicial resources because none of the claims that they could have potentially alleged would ever vest jurisdiction in the trial court. And that's what I'm trying to go down the list, is there's just nothing there. They can't make facts, remake the facts. They are what they are. And so under Monell claims are premised under section 1983. And as I stated, under Daniels, the Supreme Court case, United States Supreme Court case, you can't maintain a section 1983 claim based on the negligent act of an official, which is again what has been alleged here. Furthermore, under Monell, a city is only liable under section 1983 if a municipal policy or custom that a policymaker knew or should have known was the moving force of a deprivation of a federal right. And to prove the policy or custom, a plaintiff must show similar incidents that are sufficiently numerous and have occurred for so long and so frequently that the conduct warrants attribution of knowledge to the government. These instances must be sufficiently similar and in many cases say virtually identical to the case at hand. Appellees have not pled that. They can't plead that because such facts do not exist with regard to the city of Waco. Now, their Fourth Amendment claim fails because there's no evidence, nor can there be any that the city intentionally caused property damage in question, intentionally caused. And because there's no private cause of action for negligent property damage caused by a municipality under the Fourth Amendment.
Well, don't you think he intentionally caused property damage when he pulled the trigger?
He intended to protect himself from an impending danger posed by Finn. He did not intend to kill the dog. He intended to protect himself. When under the Fourth Amendment, typically it's for example, a condemnation. For example, it's an intentional act by the government, not in an emergency situation where they intend to take somebody's property. That gives them that private cause of action.
You're wanting to say that he did not intend to cause damage to Finn when he shot him?
He intended to protect himself is what I would say. And I do not believe this rises to what I believe you're alluding to, a constitutional taking. Because in that context, it has to be an intentional act, which there may be difference of opinion on that. But secondarily, it has to be taken for public use or for the benefit of the public. That didn't happen here. The facts do not exist here.
Wasn't the intentional act that he wanted to neutralize the threat? He intended
To protect himself, correct.
Trying to protect himself, but it was an intentional act to neutralize what he perceived as a threat. Is that fair?
I would say that's probably fair. But it still doesn't give rise to a Fourth Amendment claim
And there's
under
been,
the case law.
and there's been no pleading. This
This is all speculative at this point. We don't know what's going to be alleged.
that any intentional acts were taken.
I'm sorry.
It's all negligence.
This whole case is rooted in negligence. Yes, Your Honor.
Well, except for the intentional infliction of emotional distress.
Correct, for which the TTCA doesn't waive immunity. 42 USC section 1988B addresses entitlement to attorney's fees for vindication of civil rights. This has nothing to do with the case. It has nothing, it doesn't waive the city's immunity. We need, that's an easy one to dispose of. Applebee's Fifth Amendment due process claim also fails because it can only be maintained against a federal actor. Neither Officer Moon nor the city are federal actors. That's the end of the analysis there. Appellant has also seems to raise a substantive the 14th Amendment substantive due process claim. They mention it, but they don't argue it in their brief, so arguably it's waived. But nevertheless, nothing in this record just demonstrates deliberate and intentional actions taken by the city that were so egregious or outrageous that it would shock the contemporary conscience as to meet the 14th Amendment substantive due process standard stated by the Supreme Court in County of Sacramento, Lewis. So we don't get anywhere there as well. So everything that's been pled, there's nothing that can be pled that would demonstrate a waiver of the city's immunity. The main track that they can go on is the TTCA 101021, operation of a motor vehicle or motor driven equipment. That was not involved here. That should be that is arguably the end of the inquiry. So given the foregoing, we argue the city posits that appellees have not pled jurisdictional facts that result in a waiver of the city's immunity. Because the city's immunity remains intact, the trial court lacked jurisdiction and therefore erred in denying the plea to the jurisdiction. I'm sorry. And accordingly, the city respectfully requests that this court reverse the trial court's denial of the plea to the jurisdiction. And with regard to the opportunity to amend, the city posits that it would be fruitless. There is no point because there aren't facts that would give rise to a cause of action for which the trial court would have subject matter jurisdiction. And if there are no more questions, I will cede the rest of my time back to the court.
Thank you, counsel.
Thank you, Your Honor.
You'll have 5 minutes for rebuttal. Counsel, you have 3 minutes to address the audience as previously described. And you may proceed with them when ready.
Morning. As previously explained, this is a case where dog Labrador being 10-year-old dog was shot and killed by the Waco Police Department, Officer Moon. And I represent the plaintiff in this case. And the trial court before we came here decided that this lawsuit was going to proceed and there would be some remedy for the lawsuit. And the city of Waco has decided to challenge that, which has brought us here. There's some missing talk about whether the city is immune, regardless of there be a fault. We're saying that they're not immune on both state and federal level.
Counsel, you may proceed.
Finally reached that point in my career now where I've done enough of these oral arguments to where I realize you can shut up sometimes. You guys are asking great questions from the opposing side, and that pretty much gives me an idea of what this panel is deciding. And so with that said, I'm going to first ask, is there any questions you'd like to ask me?
If you are allowed to amend, what is it that you would allege to bring yourself within the jurisdiction of the trial court if we were to conclude that it's otherwise barred?
All right, without conceding anything.
Understood.
I would first make it very clear about 42 USC 1983 and being able to bring about private cause of action for the intentional conduct of Officer Moon. I think the great question was, what you pointed out was, when you say he intended to shoot the dog when he pulled the trigger, that's an intentional act. That's one of the things I will look at. And jimmying up the Fourth Amendment claim. I'm not conceding necessarily on the other claims that we are alleging. I think there were some new arguments raised on this level that wasn't raised in the trial court. I think the trial court level, the lion's share of the city's argument was immune from suit. I'm sorry, immune from liability instead of immune from suit. but they kind of make some more arguments clear, as he's done here today, when they filed their brief. I think that you were on to something when you asked, would they be allowed to raise their argument concerning the emergency aspect for the first time on appeal? And I believe that answer is absolutely no. They should not be allowed to make their argument for the first time. So,
Any other questions? Starting with.
all right, and I know that doesn't do much for the audience, but I want to go back to that point where I've done this enough to be quiet. So, I don't want to rehearse the matter over and over again. We all know what the issues are. The question is, how is this court going to come down on it in the end? I think that, the city ignores the constitutional arguments. Article 1, Section 19 of the Texas Constitution, and how that brings about a cause of action through other areas of Texas state law. But more importantly, they ignore the 42 U.S.C. 1983, which certainly allows for the Fourth Amendment violation for us to bring a call of action. But that's all I have to add. I'll give the rest of my time.
Oh, thank you, counsel.
Your Honors, I'll be real brief as well. First of all, with respect to the comment that the city did not raise both immunity from suit and immunity from liability in the trial court, that is false. In reading the original answer, which I would recommend, commend you all to read, in paragraph 3.1, the city says in the affirmative, the city of Waco and Moon are immune from both suit and liability in the above cause by virtue of their governmental immunity, and hereby assert the defense of governmental immunity and the exemptions, exclusions, and damage limitations of the Texas Tort Claims Act. And that was also the basis of the plea of the jurisdiction hearing as well. So I would recommend that y'all review that record, which I know you will, and determine that that was raised in both instances, because it does make a difference. The immunity from suit impacts subject matter jurisdiction, whereas immunity from liability affects money damages and allows the case to proceed. So we need to, we have raised both of those, and I think the record will bear that. With respect to the federal claims, we don't have much more to add to that than what we argued in our brief, as well as what we argued in the opening. So at this point in time, I guess like co-counsel, if you have any other questions, I'd glad to entertain that, but there's not really much else to refute at this point in time.
Okay, thank you, counsel.
Thank you, Your Honor.
This case is submitted. Counsel will be excused. We will, I did not hear any other cases, new cases cited, so we're not looking for any supplemental briefing. You're always welcome to file a supplemental briefing to clarify any point if you feel that it's there. And with that, we will stand adjourned until the 1:30 docket, and we will go to our Q&A session. So Lindsay, are you hiding behind the podium again? Why do you have to hide behind that one column right there? So, I wonder what you're doing back there. So do you have some questions for us already?
Let me check.
Okay. Okay. We have no written questions that have been submitted yet, and there goes half our questions out the door. Thank y'all for coming. We appreciate it. Officers or I don't guess they're officers yet, but students in the academy. So, are there any questions that the audience has about process, procedure? Counsel, y'all can leave the table. No need for y'all to stay there. Relax. Now, thank you.
I will weigh in on one matter. Y'all may have seen, I've been here for the first oral argument where I wasn't on the panel. The reason I wasn't on that panel, I went back and looked, was people, when you're arrested, you're charged by officer's affidavit of probable cause, and then the justice of the peace makes a decision on whether to detain you. And then after that, it moves on to the next step, and that's the case forwarded to to the district attorney's office, and the district attorney makes the decision on how to charge the case. And so in this case, in the first case, the man was charged by indictment, and then it was filed in the 54th District Court while I was still the district judge there. And so as soon as cases, any case, it wasn't this case in particular, all cases that are charged by indictment get post-indictment conditions added to their bond. So let's say they're charged with an assaultive offense, well, they can't go around the alleged victim. Let's say they're charged with a drug offense, they can't use drugs. If they're charged with a driving while intoxicated offense, they have to have an intoxilizer put in their car. And so there are certain kinds of terms and conditions that we put on their bond. And my staff did that for them, routinely, because there's so many of them. And then they bring those in for me to sign off on. That's what I did in the first case. I didn't try the first case. I was there for 3 months, and then I was sworn in as a justice here on the Court of Appeal. But the law is very clear that if you sign a document in a case that you recuse, and I do it regularly. I mean, I had a heavy docket in the trial court, so did Judge Smith. He had a heavy docket down in Brazos County. And so we had a case, I think about a year ago, where Judge Smith may have done just about the same thing, dealt with a bond issue, and he had to recuse on it. And so if you want to know why I was knocked out, it's because I actually signed off on some terms and conditions of their bond.
And man, not going further, even if we hadn't done it, sometimes there's a perception of impropriety, even though that perception is not at all accurate. But we err on the side of caution to show that we want to make sure that whatever decision is made, there is no taint in the fact that we might have learned anything about the case while we were there. And so we exercise more caution sometimes than we actually are required by law to do. But we do it simply because we want the system to be viewed by you as one that is very fair and honest.
Any questions? This is your chance. You've got 3. I understand something. Everybody's pointing, oh, you're gonna come up and use the microphone, even better.
Yes, sir, I am. Thank you very much, first and foremost, for coming here to Queen Community College and enabling the students to see your work in action. It's really something that I think they'll treasure from here on. So my first question is in relationship to public opinion, because I know that this case has been in the newspaper. I know that you are to be neutral and unbiased, but is it difficult sometimes to put that neutrality aside when you're having to make these kinds of decisions, answer these questions that you're answering? And then also, just because I teach Texas government and absolutely love it, my question is, how difficult is it for you to campaign and hear cases at the same time? I mean, is that a difficult process? So that's all I asked.
I'll add, thank you for the questions. With regard to the campaigning part, the Code of Judicial Conduct doesn't allow us to tell anybody how we would rule on a case if the issue came before us. Number one, it'd be improper. Number two, if judges were allowed to do that, and somebody came before that judge with that issue, and they had already said, well, I don't care, I'm gonna rule this way. Well, that's not a fair and impartial judge. And so due process requires that you have a fair and impartial judge who will listen to the facts and the evidence and the information of the case and make the call. And so, campaigning, there are a lot of times you just have to say, the Code of Judicial Conduct won't allow me to answer that question. And you really campaign on your qualifications, and temperament and whatever else you think is your strong suit. Anyway, but that kind of answers the question. With regard to public, criticism or criticism?
I
or
said,
maybe-
no, this has been in the news. This case has been in the news
Right.
previously, and
High profile cases
Right.
and things like that. You know, I tried a whole lot of those while I was in the district court, and, that's the one thing you have to do as a judge. You make calls regardless of what the public's going to think about it. And then you can't say anything about it. And so it really requires, a lot of restraint, and it requires you to make the right call in accordance with the law, even if people get mad at you and say things about you on on social media, things like that. But what I've always told people when I talk to them in groups that would come to the courthouse is, you know, look at the judge, not on one decision, look at them on their career of decisions. Okay, you may disagree with me on some decision, but I mean, my goodness, my wife doesn't agree with me on 50% of my decisions. And so, you know, and so look at the career, look at the track record. And that's why it's important, I think, to read the newspaper, stay informed, things like that, because you do get an idea of the track record, because one decision by a judge that may be very unpopular should not derail a career.
Yeah, my comment is sort of following on that. You know, from our perspective, we do our jobs. I've always jokingly told people, when you're a trial judge, you've ticked off half the people that you've seen every day. Because one side wins and one side loses. And sometimes you take both of them off because neither of them got exactly what they wanted to do. But as you relate to cases with notoriety or anything, I think that goes back to us viewing and looking at what we perceive the public would think if we're sitting on that case. And if it's one that deep in my heart, I say, you know, I do my best to be fair, but I really can't on this case. Any of the three of us, if we felt that, we tell the other two, we're gonna recuse. And,
In case my students do not know, can you explain recusal?
yes, recusal just means I'm going to step down as the judge of the case. And have like Rex was here as a visiting judge today. Matt and I both, when we were on the trial bench, if we recused ourselves, we would have a local administrator or regional presiding judge appoint another judge, usually a retired judge, to come in and sit for that case for us.
The two questions evidence what I will say is a public perception of what we do. And it is sometimes unfortunate that the public perception grows legs. With regard to publicity in a case, I follow the Clarence Thomas approach. I don't watch TV news. I don't read the newspaper. The first thing I learned about Finn was when I picked up the briefs and started reading. In that regard, I do what I consider or have labeled intentional ignorance of current events. One of the officers today asked me about whether or not I had seen or was aware of an incident. I think his name is Hill, a professional sports person that was stopped by the police.
Tyreek Hill.
Tyreek Hill. And I
watched.
And I'm going, I've got no idea. And then he gave me enough that I remembered I had heard it. So, the other aspect of it is I don't have time to do that. I don't do social media, of any type other than just family emails kind of stuff. It is not uncommon for me when I get to the point of doing an opinion or reviewing one that has been presented to me by either of the other judges, that I don't know who the parties are involved. I don't know who the lawyers are that are involved. What I know is the facts and the law. And in answer to your second question, I have found it actually incredibly easy for me as a judge to divorce myself from public opinion, from whatever might be swirling around the case, and decide on the law. And there just haven't been that difficult. I thought I would have that after campaigning the first time with The very first time was, for the primary. I had no judicial experience up until the time of the primary, then was a municipal judge for a year during the time to the general election. And that gave me a better understanding of what happens at the jail and arraignment and that kind of thing, but, I was surprised at how easy it was if you are a student of law to just apply the law. And, I hope that's the way we all approach it.
Justice Scalia once said, he said, if you are a judge and you like every decision you make because it's what you wanted to do, you're not a good judge. So believe it or not, there are times when I don't like the decisions that I've made, but I follow the law. I've been true to the law. I may feel like, well, that person, the law really cut against them. But follow the law and that's what you really have to do. So sometimes, Caitlin, we don't like the results but we don't go for results. We go for following the law and getting to that answer.
Excellent questions.
Thank you.
Anybody else? Anything? Got it wide open. Lindsay,
Yeah,
are you holding a question or are you just hoping that there's another?
I'm just hoping. I have a question.
Yes.
So what advice would you give to a young adult that's possibly seeking a career in criminal justice or in becoming a trial, or well, I guess just a lawyer in general?
We're gonna start with the oldest person on the bench to answer your question.
He always tries to work that in.
And have I ever failed?
Never has failed. I came to the law by accident. You're looking at a guy who holds a degree in music education. I was going to be a band director. Started out as a pre-med major because everybody wanted me to be a doctor. The only problem was I didn't want to be a doctor. And so a good friend of mine, who's an attorney in Abilene, we were classmates, and she said, "Steve, you need to go to law school." So I said, "Okay, I'll go to law school. And I'll stay here, and if I don't like it, I'll still teach music." And just so you'll know, I still have my teaching certificate in my office in Bryan, just to remind myself I can go back and do it if I wanted to. But I think it's a wonderful profession. It's a profession that can be dangerous to your family because you can spend too much time doing your job and not enough time with your family. Fortunately, I didn't have that problem. And what I would do is if I was thinking about it, I would do just exactly what you're doing today. Come view this, go down to the courthouse in downtown Waco, watch some trials, see what you think, because not everybody's a trial lawyer. We've got lawyers who do mergers and acquisitions. We have lawyers who help people probate their wills. We have lawyers that do family law, God bless them, and other things like that. But if you have an interest, establish a relationship with an attorney, find somebody. There's somebody you know that your family knows. Talk to them. What's it like? And then spend a little time in a courtroom. And if you have sort of an interest in it, give it some thought and take the LSAT and see what happens.
I'd say, you know, you can always shadow a legal professional, do an internship in a law office, asked to do those kind of things. Most of the public officials that are involved in law, judges and folks like that, if I'm asked for, whenever I was asked to have interns or people just shadow me for a week or watch what we do, I would allow them to do that. And so that's one way to kind of see if it's really what you want. I'd say, you know, test the waters a little bit that way instead of deciding that once you're halfway through law school, it's not for you, things like that. Because that's a lot of time and resources that would go for naught.
Rex, come up.
Sure.
Come up and join us. There's a.
Now, hang on just a second. He's the oldest judge here.
Are you sure about that?
I'm positive. We discussed it last night. Not very much, but
Yeah, 18 months older than he is, not much.
we both go to the same hairdresser.
What's up? Yeah, you've got a microphone out there. Pick it up.
I've been told by you many times I don't really need one, but that's okay. That's fine.
You can actually speak to the other one there and
This one,
yes, if you,
I was on this bench behind me for 19 years and 7 months. Tom and I spent a significant amount of that time together, about 15 years of my time. And then these other two guys have become good friends of mine along the way, and we've all enjoyed each other's company, you can probably tell that. And so when I retired at the end of 20, there were two things notable in my life. One, Tom had asked me and asked one of our staff attorneys to man the Court of Appeals for the year before that, because there was something called COVID that had permanently affected all of our lives. And I lived in Waco, the staff attorney lived there. We were both crazy enough to take his request and take it on because none of us really knew how we'd wind up. The courthouse needed to be manned, and we did. So at the end of December of 20, I retired. I finished my last term of office then, and we were still had COVID hanging over us. So for 90 days, I quote, stayed retired, and it drove me crazy. Because I'm not built like that. And I'm happy for my friends who retire and can fish and hunt and do other things and travel, and it's great. I got nothing wrong with that. But I am fortunate that we have a visiting judge program in the state. What that means is we don't have at times, when you hear about the recusals up here, or that happen on occasion, I'm blessed because I get to sit as a visiting judge by assignment, both in trial work and appellate work. And I'm doing it currently in about 5 different counties in Central Texas. And I thoroughly enjoy it. We're under the same ethics, we're under the same guidelines, but two things don't occur. One, I don't have to run for office. I ran for office, fortunately, successfully, a number of times in my life. But also, we are not expected to raise money to run for office, which is, you might wonder about that. So the point is, I am now 3+ years down the road doing visiting judge work, and I'm blessed that this court asks me from time to time to sit with them. And I'm blessed that I have a Regional 3 administrator who's actually just north of San Antonio. We have big geographic territories. And those people are the people that assign us, match us up when we need it somewhere else. I'm currently doing civil, criminal, juvenile, probate, all of those kind of cases, and I love it. I just think it's great. And my wife loves it because I'm not in her house most of the time. But just from a perspective of a visiting judge, that's how my life progresses at this point.
in answer to your question, do it, no, I'm talking to the person that asked the question. Just
Oh, okay.
have a seat, stay close. We may have another question for you here, Rex. Do it because you want to do it, not for somebody else. It's gotta be something that you wanna do or you'll be miserable. There were no lawyers, in, my family. I knew nothing about the practice, had no idea what I was getting into. And, it was still the right decision to make because it was something I wanted to do, and it worked out well for me. So, and y'all may wonder about how long we're gonna stay here in the Q&A session. Obviously, we got a short argument at the 11 o'clock docket, so I feel comfortable staying a little longer than I normally would. So feel free to use this time because we want to answer your questions. It's Constitution Day. That's why we're here. We are here to share what experiences we have had. And, so, next. I saw a finger, now it may not have been for a question.
So I came from civil law system, and I'm just asking for some advice, where I can start to understand how common law, works.
Well, it is interesting that you asked the question, and let me see if I can rephrase it. You are, not familiar with the legal system, and you're wanting to know how you get involved in the schooling, training of law.
That's right.
Oddly enough, I was a junior in college, summer before my senior semester. And I thought I wanted to be a lawyer. I won't take you as far back as my initial aborted attempt at going into the military to get the GI Bill to go to college. But what I learned in that summer is there's something called an LSAT, Law School Admissions Test. It's like any other advanced degree test that has to be taken. I didn't know it existed. I didn't know a thing about it. The guy asked me how I did on the LSAT, and I said, "The what?" And so we started a conversation. What I had been told and what I relied upon was just conversation, public conversation about this. I strongly recommend, if you are thinking about it, don't do it like I did it. Do it a different way. What I would suggest as appropriate, as Matt and Steve have both talked about, if trying to do an internship, you can do that even while you're in college. You don't necessarily have to be a law student to be an intern at a law firm. One of the guys that I started law school with, there used to be a firm here in town, right now I forget the first name, Cherry and Davis, and he was a runner for them. And he just basically got minimum wage for doing anything that they needed him to do at that firm. And it confirmed for him that he wanted to be a lawyer, and he got to watch them. I would say that watching it on TV is not the way to do it. That's not authentic. But fundamentally, what I would suggest is you need a 4-year degree. You need a 4-year degree in something that is challenging. Now, Steve was self-deprecating when he talked about his music degree and how far afield that was. There seems to be away from the law. But if you understand music like he does, it's not that far afield. It's organized, it's measured, it's metered, there's patterns to it. That's what you're looking for in the law. But and it's also a very challenging degree to be able to study a subject that is so boring it puts the rest of us to sleep. But my point is,
But you enjoy listening to it.
yes, yeah, just you turn it on and you go to sleep. That's the way it works. Yeah. So get your 4-year degree. I also suggest that you get that 4-year degree in something that has a fallback position. Mine was CPA, public accounting, business degree, and then an MBA in accounting. And I actually went out and did public accounting for 3 years before I went back to law school. The point of that part of my answer is that you may get into law school, you may do it well, and you may decide you hate it halfway through. You need something to fall back on. So that's why I recommend you take something challenging, you take something that you can fall back on, and then I always hesitate to focus on grades, but it does matter. Doing well in high school and then college and then law school matters. You'll get a job. there's enough demand for lawyers that you will get a job. The question is, will it be in what you want to do? Will it be the best job? Will it be in the best location? Will it be where you want to practice and practice the kind of law that you want to practice? Because as Steve said, there's a whole lot of different kinds of law. I mean, when I first went to Corsicana after I graduated from Baylor, I thought that I was going to do some probate law and business transactions with maybe some foray into litigation. And because litigation put food on the table, that's why I'm here now. So
I would follow up with one thing, regardless of what you choose to major in. Learn how to write. Take a good English course. Take a couple of good history courses. And take at least one elementary accounting course. So that if you become a lawyer and you have your own firm, you'll know what it's like to read a balance sheet and understand the finances.
well, with my CPA background, there wasn't a case that I was involved in. I didn't do criminal work. So there wasn't a case that I was involved in that did not involve money. It's all about money, damages, something. And I wound up working on the damages model in virtually every case that I was on the entire time that I was in private practice. Yeah. Good question. Thank you. Yes, ma'am.
You explain to the students why there might be that their attorney to come before this court that are representing the appellants or the appellees that were not the attorneys in the trial court.
Sure.
Some people decide to specialize in doing appellate work. You can actually become board certified in a lot of different areas of law, civil trial, personal injury trial law, tax, family, and one of them is appellate, both civil appellate and criminal appellate. Some people are more outgoing and like to be in a trial situation and like to participate in front of juries and judges. Others are not quite as gregarious, but very, very smart. And so I would always say that the smart thing to do is to get a good appellate lawyer after you've had a good trial lawyer. They don't always equate to each other. I know some really, really good people who are both great appellate lawyers and great trial lawyers, but that's why you'll sometimes have one or the other.
When I was on the district bench, I would appoint the trial lawyers, and then I would appoint a different appellate lawyer. Partly because there can be a little bit of a conflict if the trial lawyer is looking over his trial work for potential error. And sometimes it rises to the level of ineffective assistance of counsel. And so you can't have the trial lawyer who might have had a bad trial, had a bad situation going on, taking the appeal up. And so I was always real careful. I can't think of very few times whenever I did not appoint a different lawyer for the appeal versus the trial.
There's a young lady in the back that's been wanting to ask a question. Please come forward and.
Hi, I had a question about the trial itself. Did Finn have a history of attacking others? And if so, why was he trying to attack that specific officer and not any of the other officers, but just that one? Could it be that he smelled something on him?
That's about the specific case, and we've got to decide that case, and we can't really talk about that deep level of detail. The facts that were discussed in the briefs and here in front of us are what we'll be going by, what's in the record, and that record reveals that they called out, that they were present, and that the time between the call out and the shot was 6 seconds.
Okay.
And so there the questions that you've asked about, I don't even know if they were developed in the record or not, so we wouldn't know.
Okay, thank you.
Thank you.
Rex, would you like to address the question about, specialists? You were in private practice longer, probably than all three of us.
Did you say specializing?
Yeah, the
Yeah.
special is between the trial work and the, appellate specialist.
Yeah. Well, they're all absolutely right about perspective. And I also understand, Matt's concern about having a different lawyer in the criminal area particularly. The other thing that will drive part of your decision is that if you're gonna get into the business, you can make a satisfactory, sometimes more than satisfactory living financially. But it is a misnomer to believe that lawyers are all wealthy people. It's like 1% of the population, the proverbial 1% of the population. It's a small digit, probably a little above that, not much. But you can make a very satisfactory living doing those kinds of things. The other thing that drives the two trial judges behind me is that they have to be concerned about is that we have the constitutional protections for people who are charged with crimes from the B misdemeanor in our statute all the way up to the felony process. And that means if there's any potential essentially of incarceration, jail time, person's entitled to an attorney if they can't afford one. And all four of us jealously protect that. Okay? That's ingrained in our souls. So take comfort in that. But what happens is if you can't afford to have an attorney and you have a client charged with crime, then you get a court-appointed attorney. And there's a system in each county in Texas where there's a list of attorneys that are available and they get paid a basic stipend per hour, that's still per hour. Isn't it?
Yes, sir.
That, they get paid a base pay, but I will assure you, they don't get rich being a court-appointed attorney. So the judges are sensitive to, in a positive way, they want quality representation for anybody charged with a crime that has the potential of incarceration. But they also want to spread it around because you're not going to get rich doing that. Likewise, on appeal, the rate is set if it's going to be somebody needing to be appointed on appeal. So, for instance, a very good criminal defense lawyer will generally have a mixed practice of people who can hire that lawyer and being appointed to represent people because some people can't afford them. So in our business, you have to understand that has to be, we have to be sensitive to that and knowing that and how that works. Now, your other question is going to be, and now I've got 3.5 years of trial work behind me as a judge. And then as Judge Gray said, I had 27 years as a practitioner before all that. Yes, I am that old. This year I celebrated being a state bar lawyer judge for 50 years. I know, I thought that was kind of good too. And we had a nice little celebration in Dallas recently when they recognized the old ones are still standing. So the point is that you, if you're gonna get into the business, you've already seen these folks all express a love of the business, the love of the profession. That needs to come with it. But there are so many different ways. I did all kinds of trial work, civil, criminal, in my 27 years. And then as a judge, I was blessed to do what we do, which is basically we get to do all kinds of subject matter. You might not have totally understood that today, but that's what we got. I mean, you got a criminal case, you got a civil case, and then the other one's a criminal case. Right. Yeah. So, but there's a variety of those things, and likewise, I get to do that too. So, if you think you wanna do it, go for it. Don't feel like you're gonna get rich doing it. Do it with a passion. And if you like it, then you chose wisely. If you didn't, use that legal education as the chief talked about just a minute ago. And use it to apply in other ways in your life if you need to, or the undergraduate degree that Justice Smith had, he was able to apply and go on forward from there. Did I answer what you wanted? Yeah. Okay.
Oh, gosh, we've got more questions now. All right, we need to wrap it up. I'm gonna go to the back row first. Yes, ma'am.
I just want to know, like, after judging your career over the course of time, do you feel like you've aided humanity in getting better and better over time, or does it just make you feel more aware of all that?
Repeat the question. So,
Well, basically, do you feel like you've done a really, really good job, or are you just in a position where you're saying, oh, gracious me, it's another bad day of people that I really can't believe they're doing stuff? Share one quick story. Young lady on probation, formerly worked at the DA's office, not a lawyer. Got hooked on meth, put her on probation. Asked me to let her to go to her son's graduation for 10 hours. I said, you can go an hour before the graduation starts and gotta be back in jail an hour after the graduation's over. Got a letter from her 2 years later, and this is how it started. Dear Judge Smith, thank you for saving my life. I got a good job.
I've had the same experiences. Sometimes you feel like you may just be going through the processes, but it's those letters that you receive 2 years, 4 years, 5 years later, saying you saved my life. And I actually, one lady approached me one time, Judge Smith was with me, and I said, no, I gave you the motivation, maybe. I gave you the right circumstances. I gave you probation parameters and guide rails. That's what I gave you, but you had to, want to fix yourself.
and there was another question. Yes, ma'am.
Yeah, thank you, Your Honor. I wanted to ask how you stay current with changes in the law and legal proceedings when there's just so much information.
It's like drinking water from a fire hose. Every decision by the Court of Criminal Appeals, Texas Supreme Court, United States Supreme Court are binding on our court. Then every other court of appeals, and there are now 14 other courts of appeals across the state of Texas, besides the 2 high courts. Every other court that can write an opinion, which includes all federal district courts and Fifth Circuit or courts of appeals in the federal system, they can all write opinions that may influence or that we may find persuasive. Legislature every 2 years changes all kind of laws. We have a near 15 hours of continuing legal education required each year. There is no human being that can maintain proficiency in all the disciplines in the law. It is impossible. I don't even think artificial intelligence can do it. It is a challenge, but the way we do it is, you've heard all the judges talk about different specializations or different areas of focus. That's what you do. You focus on an area. Mine happens to be appellate law. Across that spectrum that is an entire body of law in and of itself. And then all these other bodies of law will come into play at some point during an appeal. Any particular one of those bodies of law could be pertinent. It is focus, it is time. And then kind of what Steve referred to, your family can suffer because you spend so much time being focused on the law. And I'm a workaholic, and so I'm probably in that camp, but it is, it's like anything else that you do that you really enjoy. You can keep up. But as the first lawyer that spoke today, she was talking about a dissent that I had written in a previous case. Been doing this 26 years. I don't remember it. I'm gonna go find it. I'm gonna see how it fits in, but we have a challenge based on the volume of work that we do, keeping our own cases in sync, that we decide each case consistently with what has gone before. And so your question really has several levels on it, because you've got that narrow focus on one of the critical components of the common law, is that when this question comes back to us in the future, we answer it the same way as we did the last time that question was posited to us. But at the same time, it's global. Also in the first case, one of the arguments is that other courts of appeals do this a different way. And that, if you didn't see it in the briefs, but in the briefs in that case, they cited cases from outside. I'm sorry, I'm talking about the one this afternoon. They have cited cases outside of Texas for the proposition that they are going to be arguing to us. So we can't begin to keep up with everything. It is the lawyer's burden to bring it to us. And as much as I would like to give them an opportunity to respond to your excellent question, I've got to shut this off somewhere. I'm already 10 minutes over. And so unless anybody's got a life-changing question that you have to ask in the forum, I'm going to go ahead and shut it down. Approach one of these judges or myself, and maybe you can quickly ask us, come back at 1:30 and we'll do this again. Thank you.
So he wants to know if you can interview one of you. Did you want to do that?
Yeah. Yeah.
You will. I'm